16. Reading Cases. Hi Alex. In this letter, I'm going to talk about one of the most important parts of a law student's legal education: reading and making sense of cases. Up until the 20th century, most English law was case law that emerged from the concrete decisions of the courts. Out of thousands and thousands of cases, each presenting a set of facts and a question. What does the law say in this situation? There emerged the body of rules and principles that is known as the common law. The tidal wave of legislation in the 20th century has reduced the importance of the common law, but large swaths of our law, especially administrative law and tort law, are still very much based on case law. So you will be expected to read cases and be able to discuss them in your legal essays and problem answers. Taking notes on a concrete case. Let's start with a concrete case. Century Insurance Co. Limited v. Northern Ireland Road Transport Board. I'm sending you a copy of the report of the case in 1942 appeal cases. Don't worry about what appeal cases mean. I think I'll write you another letter about the whole history of law reporting, so that you can make sense of all the different sets of law reports. For the time being, let's just say that the appeal cases, or AC, for short, report cases decided by the highest court in the UK legal system, previously the Judicial Committee of the House of Lords, or House of Lords for short, and now the UK Supreme Court. So Century Insurance is a case decided by the House of Lords. Now, if you were making a note on this case, you would start at the top of the page with the names of the parties, the citation of the case, and the court that decided the case. So, Century Insurance v. Northern Ireland Road Transport Board 1942 AC 509 HL. Again, don't worry about why the year is written down as 1942, with square brackets, rather than 1942, with round brackets. I'll tell you about that in the next letter as well. The next thing we want to make a note of is the facts of the case. Now, 2 points in particular need to be borne in mind in summarizing the facts of the case. First, we are not at all interested in who the appellants and respondents in the case were. Technically, the appellant is the person who lost in the court below and is now appealing against that decision. The respondent is the person who is responding to the appeal and hoping that the court will uphold the decision of the court below. But the technicalities of who was appealing and who was responding to the appeal are completely irrelevant to us. So your summary of the case must not make any reference to appellant and respondent. If you use those terms, you won't have a clue who you are actually talking about. What matters for our purposes is who is bringing the action: a claim for damages, a criminal prosecution, an application for judicial review, and who the action is being brought against. And ideally, we'd like to put actual names to those people, as a summary of the facts is easier to write and easier to remember if we can put a name to the people involved. Secondly, the headnote to the case will normally provide you with a good starting point for your summary of the case. If you turn to your copy of the report in the Century Insurance case, the headnote is the summary of what happened in the case and what was decided. That is on the first page of the case, page 509. The headnote starts under a contract with a petroleum company and ends entitled to be indemnified under the policy. But you must not just copy out the headnote's summary of the facts of the case and adopt that summary as your own. The headnote will normally tell you enough about what happened in the case for you to produce a summary of the facts of the case. But the headnote's summary of the facts will probably be too long and overcomplicated for your purposes. You need to produce a summary of the bare essentials of the case. As it happens, the headnote of the Century Insurance case isn't that great at making it clear what exactly happened in the case. We start off with a transport undertaking, which entered into a contract with a petroleum company to deliver the petrol company's petrol in the transport undertaking's lorries. I'm already getting a bit irritated with the lack of names, so let's just try to see if we can put some names to some people here. For that, we need to skip forward to the judgments for a more detailed account of the facts. As it happens, that more detailed account is set out on the very next 2 pages, pages 509-10. But that starts unhelpfully by talking about the respondents being insured by the appellant company. And no names. So we need to go back to the first page and look at the title of the case to see who the appellant and respondents were. And we see that Century Insurance were the appellants and Northern Ireland Road Transport Board were the respondents. The Northern Ireland Road Transport Board must be the transport undertaking. But what's the name of the petrol company? Going back to page 510, we eventually find a reference to a consignment of 300 gallons of petrol at the Larne Depot of Holmes, Mullen and Dunn LD. That must be the petrol company. So, the Northern Ireland Road Transport Board entered into a contract with a petrol company, HMD, to deliver HMD's petrol in its lorries. Fine. So what happened next? Back to the headnote to find out. According to the headnote, the Transport Board for short undertook to do various things for the petrol company. But we know now that the petrol company isn't involved in the case, so that might not be worth making a note of. Okay, so what happened next? This is what the headnote says. While one of the lorries belonging to the undertaking, in respect of which a policy had been issued by an insurance company against liability to third parties arising from damage to property caused by its use by the undertaking, was being used to deliver petrol at a garage in accordance with the agreement, the driver, while transferring petrol from the lorry to an underground tank, struck a match to light a cigarette and threw it on the floor, causing a conflagration and an explosion. Okay, how could we sum this up? We know the undertaking is the Transport Board. The insurance company is almost certainly Century Insurance. So, Century issued an insurance policy to the Transport Board TB under which it would cover any liabilities incurred by TB to third parties arising from damage to property caused by. The next bit of the headnote says, its use by the undertaking. What does the its refer to? Looking at the sentence, it seems to refer to one of the lorries belonging to the undertaking. So, Century issued an insurance policy to the Transport Board TB under which it would cover any liabilities incurred by TB to third parties arising from damage to property caused by TB's use of its lorries. When one of TB's lorries was being used to deliver petrol to a garage, the driver, while transferring the petrol from the lorry to the garage's tanks, struck a match to light a cigarette, threw it on the floor, and caused an explosion. Fine, and then what happened? The headnote says, claims in respect of consequent damage having been made against the undertaking, the insurance company contended that they did not fall within the scope of the policy. Putting this in another, less abrupt way, TB was sued for the damage caused by the explosion. It sought to claim on its insurance policy, but Century said it wasn't liable under the terms of the policy. But this isn't completely satisfactory as a summary of the facts. We don't know why Century said it wasn't liable. To find that out, we again need to flip over the page to the more detailed statement of the facts in Viscount Simon's judgment, and look through it for something that will tell us why Century thought they weren't liable under their insurance policy with the Transport Board. And at the bottom of page 510, we find that one of the grounds on which the appellants resisted the claim of the respondents under the policy was that, in view of the terms of an agreement of October 11, 1934, between the respondents' predecessors, the Irish Road Transport Co., LD, whose undertaking they acquired on April 30, 1937, and Messisholmes, Mullen and Dunn, LD, the liability for the damage did not rest on the respondents. Ignoring all the stuff about the Irish Road Transport Co., which doesn't seem relevant at all, the important thing to take away from this is that Century said they weren't liable under their insurance policy with the Transport Board because the Transport Board wasn't liable for the damage caused by the explosion. So, TB was sued for the damage caused by the explosion. It sought to claim on its insurance policy, but Century said it wasn't liable under the terms of the policy because TB wasn't liable for the damage caused by the explosion. Putting all this together, here's our summary of the facts. The Northern Ireland Road Transport Board entered into a contract with a petrol company HMD to deliver HMD's petrol in its lorries. Century issued an insurance policy to the Transport Board TB under which it would cover any liabilities to third parties incurred by TB arising from damage to property caused by TB's use of its lorries. When one of TB's lorries was being used to deliver petrol to a garage, the driver, while transferring the petrol from the lorry to the garage's tanks, struck a match to light a cigarette, threw it on the floor, and caused an explosion. TB was sued for the damage caused by the explosion. It sought to claim on its insurance policy, but Century said it wasn't liable under the terms of the policy because TB wasn't liable for the damage caused by the explosion. Now, if you compare this summary with a summary of the facts in the headnote, I think you'll agree that our summary is much clearer and more straightforward. And all the work we have done trying to get the facts clear in our head will be helping get those facts into our head for the long term, so that we'll never forget what happened in the Century insurance case. This is one of the reasons why it's good to read cases in their original reports, rather than packaged up in a cases and materials book. Sometimes it's not good for you to have someone else do all the hard work for you. Having said that, there are some cases where the facts are so hard to make sense of that you'll need some help from academic authors to get an idea of what actually happened in the case. So now we have the facts straight. Let's pause for a second and think, what do we think the result should have been? The whole case turns on whether the transport board was liable for the damage caused by the explosion that happened when one of its drivers, who was delivering HMD's petrol to a garage, lit a cigarette and threw the match away. Thinking about this is helpful for 3 reasons. First, doing this sort of thing helps educate your legal instincts. It gets you thinking like a lawyer instead of just being a passive recipient of legal information. Secondly, it helps you test the legal knowledge you have picked up so far from your textbook reading. Can you remember enough to make an educated guess as to what the outcome of the case would have been? Thirdly, it gives you some skin in the game, as the saying goes. If you have already taken a side in the case, it makes the judgments much more interesting to read and get through. So we've got our facts straight, and we've had to think about what the outcome of the case should have been. The next job is to make a note of what the outcome actually was. Again, the headnote will tell us this, in the bit of the headnote which comes after held. There it tells us that the House of Lords found that Century was liable under its insurance policy with the Transport Board. The Transport Board was liable for the damage caused by its driver, because 1, he was employed by them at the time of the explosion, and 2, he was acting in the course of his employment when he carelessly caused the explosion. Now that we have noted the outcome of the case, we can turn to the judgments. When we go through the judgments, we are looking for added value. We are looking for anything in the judgments that adds something of value to what we already know about the case. So, for example, we are not looking for bare statements that the employee in Century Insurance was acting in the course of his employment when he lit his cigarette and threw his match away. We already know that. We are looking for explanations as to why the court held that he was acting in the course of his employment when he did this. So we skip past pages 510 and 511, as they just deal with the facts of the case, and we already have those straight. We move past page 513, as that contains the barrister's arguments in the case, and we're not really interested in those. We just want to get on to the judgments, and they start with Viscount Simons on page 514. So let's start noting that. As we go through the judgment, we are looking for statements of principle or observations about the law. We are not really interested in quotations from other cases. We want to know what the judges said in this case. So whenever you see a judge quoting from another case, you can skip past that bit of the judgment. Don't feel bad about not reading it. It's an essential skill for getting through cases quickly, the ability to skip the bits you don't need to know about and focus on the really important parts. It's a skill that students take time to develop, which is why they are so slow in reading cases initially. But once you get the hang of it, you can get through a serious number of cases in a day. And of course, if you never read cases, you will remain for the rest of your life a real slow coach in reading cases. Not a great thing to be if you are a practicing lawyer who needs to master a lot of legal information very quickly. What I want you to do is to set aside this letter and just look at Viscount Simons' judgment and make some notes on the judgment. Then come back here and look at my summary. Just to make sure you don't look at mine before you've done yours. Here's a picture of Viscount Simon to provide a break in the text before I launch into my summary of his judgment. Now go away and only come back when you have done your summary. Okay, here's my summary. Viscount Simon. First issue, who was driver employed by M can be generally employed by X. But because of arrangements between X and T, M can at the time he was careless be held to have been T's employee, so as to make T liable for M's carelessness. Test for whether X or T was employer at time M acted depends on who had power to control what M did. Employee in this case was under Transport Board's control. Never lent their lorries and drivers to HMD. Second issue was driver acting in course of employment. Driver's duty to watch petrol as it flowed from lorry into tank. And it was while he was watching that he lit cigarette, so was acting in course of employment. Plainly negligent in discharging duties he was employed to perform. And that's it. How did you do? If your summary is quite a bit longer, don't worry about it. As I said, it takes time and practice to learn how to note cases properly. Just by trying to make a summary of Viscount Simon's judgment, you are taking a first step down that road towards becoming an expert on noting cases. In looking at my summary, I want you to observe in particular how I've noted Viscount Simon's judgment. My notes are written in an abbreviated style, with no attempt to write in full grammatical sentences, and they are presented in a broken-up form with dashes and arrows to indicate the chain of reasoning. While we are not particularly looking for a fun or interesting way of making notes on cases, we are looking to ensure that our notes are easy to follow and take in at a glance. So avoid big chunky paragraphs of text. Break the text up so that the eye can slip over your note like a skier slaloming down a mountain. Having noted Viscount Simon's judgment, you can move on to the following judgments and note them as well. But remember that you are always looking for added value. So if a judge says essentially the same thing as a judge whose judgment you have already noted, then there's no point in making notes of the second judge's decision. It doesn't add anything to what has already been said. There's actually only one more substantive judgment in this case from Lord Wright, and it doesn't seem to add very much to Viscount Simon's judgment. There is one passage that looks like it might add something, on the issue of whether the Transport Board's driver was acting in the course of his employment when he lit his cigarette and threw his match away. The passage goes as follows. The duty of the workman to his employer is so to conduct himself in doing his work as not negligently to cause damage either to the employer himself or his property, or to third persons or their property, and thus to impose the same liability on the employer as if he had been doing the work himself and committed the negligent act. This may seem too obvious as a matter of common sense to require either argument or authority. I think what plausibility the contrary argument might seem to possess results from treating the act of lighting the cigarette in abstraction from the circumstances as a separate act. This was the line taken by the majority judgment in Williams v. Jones 2. But Meller and Blackburn J.J. dissented, rightly as I think. I agree also with the decision of the Court of Appeal in Jefferson v. Derbyshire Farmers Ld. 3, which is in substance on the facts indistinguishable from the present case. But in fact, it's very hard to see what point is being made here. Remember the iron rule of lawyering that I talked about in my second letter to you: express yourself clearly or die. Here Lord Wright has not expressed himself clearly, so his judgment must die and remain unnoted by us. So let's put the whole case note together and see what it looks like. Century Insurance v. Northern Ireland Road Transport Board 1942 AC 509 HL. The Northern Ireland Road Transport Board entered into a contract with a petrol company HMD to deliver HMD's petrol in its lorries. Century issued an insurance policy to the Transport Board TB, under which it would cover any liabilities to third parties incurred by TB arising from damage to property caused by TB's use of its lorries. When one of TB's lorries was being used to deliver petrol to a garage, the driver, while transferring the petrol from the lorry to the garage's tanks, struck a match to light a cigarette, threw it on the floor, and caused an explosion. TB was sued for the damage caused by the explosion. It sought to claim on its insurance policy, but Century said it wasn't liable under the terms of the policy because TB wasn't liable for the damage caused by the explosion. The House of Lords found that Century was liable under its insurance policy with the Transport Board. The Transport Board was liable for the damage caused by its driver because 1. He was employed by them at the time of the explosion, and 2. He was acting in the course of his employment when he carelessly caused the explosion. Viscount Simon. First issue. Who was driver employed by? M can be generally employed by X, but because of arrangements between X and T, M can at the time he was careless be held to have been T's employee, so as to make T liable for M's carelessness. Test for whether X or T was employer at time M acted depends on who had power to control what M did. Employee in this case was under Transport Board's control. Never lent their lorries and drivers to HMD. Second issue was driver acting in course of employment. Driver's duty to watch petrol as it flowed from lorry into tank, and it was while he was watching that he lit cigarette, so was acting in course of employment. Plainly negligent in discharging duties he was employed to perform. With that note in your files, you'll never have to look at the case again. Case notes. Case notes are different from your case notes. In other words, your notes on the cases you have been told to read. Case notes, as I explained in my letter giving some general tips on studying law, are summaries and comments on cases usually written by academics for journals such as the Law Quarterly Review and the Cambridge Law Journal. Case notes are hugely useful. They can provide you with a handy summary of the facts of a very complex and convoluted case. They also provide you with a bit of critical perspective on a case, which it can often be difficult for a student to achieve on their own. And at a time when, frankly, a lot of judges write in such a boring and prolix way, they can provide you with a shortcut to understanding what exactly were the key points of the judgments in the case. So I would strongly recommend that you get used to reading case notes, particularly on the most important cases on your reading list that are the most likely to be relevant to essay questions in the exam paper. So how do you find a case note on a case? Suppose you are looking for case notes on the case I mentioned in my very first letter to you, a V Secretary of State for the Home Department, the Belmarsh case. How you find some case notes on that case depends on whether you have access to Westlaw or not. If you have access to Westlaw, then go to Westlaw's homepage, click on Cases, and type in a V Secretary of State for the Home Department in the box for Party Names. That name is pretty generic, so you might also want to type Belmarsh into the free text box so as to help narrow the search down. Press Search, and Westlaw will then bring up the details of quite a few cases where a V Secretary of State for the Home Department matches your search. You'll know from your textbook that the case was reported in 2005, so you should scroll down the list of cases, looking for cases decided in 2004-5 with some reports of cases. They come out a year after the case was actually decided, with the right name and the right sort of keyword headings underneath the name. Eventually, you'll find the case, it's number 39 on the list, that Westlaw has brought up for me. Click on the Case Analysis link underneath the name of the case, and then in the left-hand menu click on Journal Articles. This will bring up a list of all the journal articles that deal with a V Secretary of State for the Home Department. Only a few of these will be the case notes we want. Case notes are written very shortly after a case has been decided, so we want to scroll down the list of journal articles until we get to some that have been written in 2004-5. And we are looking in particular for short articles 2 to 4 pages written in the Law Quarterly Review LQR for short, and the Cambridge Law Journal CLJ. They are our primary source of case notes. After a bit of scrolling, we eventually find a journal article entitled Proportionality and Discrimination in Anti-Terror Legislation, which has the citation CLJ 25, 642, 271-3, and an article entitled Rights Brought Home, which has the citation LQR 25, 121 Joel 359-364. The briefness of both of these articles makes us hopeful that these are the case notes we want. Click on each of these links, and you will be taken to a page with a brief outline of what the article says. Click on the link under the author's name, and you will be taken to the complete article, which you can download onto your computer by clicking on the little envelope at the top right-hand corner of the screen. Not all journal articles mentioned on Westlaw are available online through Westlaw, but articles in the CLJ and LQR are. With those two notes safely downloaded onto your computer, you can explore the other journal articles to see whether any of the other articles published around 2004-5 contain useful case notes. Journals particularly worth looking out for are the Oxford Journal of Legal Studies, OJLS, for short, though that tends not to publish case notes, the Modern Law Review, MLR, Public Law PL, specializing in the area of law dealt with in the Belmarsh case control of government action, and the Conveyancer and Property Lawyer, Conv, useful for case notes on land law or trusts law. But don't spend too long doing this. It's easy to get lost in a blizzard of journal articles, and to start fooling yourself that you are actually achieving something by looking through these articles and downloading them to your computer when you haven't actually started reading any of them. The philosopher Arthur Schopenhauer once observed that many people mistake the act of buying a book for actually reading it. And the same could be said of the act of downloading an article. If you don't have access to Westlaw, you'll have to do a physical search of the journals in your university law library. Again, focusing on the Law Quarterly Review and the Cambridge Law Journal before having a look through other journals. Pick out the volumes for 2004 and 2005 and simply look at the table of cases at the front of these journals to see where the case you are looking for is mentioned. But make sure you don't end up reading a case note on the wrong court's decision. You want to find case notes on the House of Lords decision in the Belmarsh case, not the Court of Appeals. Now, a few words of caution. First, you won't be able to find case notes on every case you are told to read. Case notes on cases decided before, say, 1980, and cases decided very recently are thin on the ground. If you want to get any critical commentary on pre-1980 cases, you have to look at the textbooks and proper full-length journal articles. To see what a textbook has to say about a particular case, just look in the table of cases at the front to see where the textbook deals with that case. To see whether there are any full-length journal articles dealing with the case you are interested in, Westlaw is again the best place to search, though it is very important again that you place a strict time limit on how long you search for articles on a case. Critical commentary on very recent cases will be hard to come by. The best way of seeing if there is anything out there on a particular case that has just been decided is to do a Google search for it. Occasionally, barristers, chambers, or academics will rush out a blog entry on a case that has just come out. A lot of legal publishers now run update websites to accompany the textbooks that they publish, and those websites might be worth looking at for comments on recent cases. So, for example, the website that accompanies my tort book, www.milachambercoworking contains twice-yearly updates on recent tort cases. Secondly, as I said earlier, case notes tend to be written very quickly after a decision in a particular case has been handed down, and they also by convention tend to be quite short. Neither of these things exactly help academics produce intelligent commentary on the cases they are writing about, though they can generally be relied on to summarize the case well. So don't believe everything you read in a case note, and try to get a balance of views by reading more than one case note on a particular case. Further tips. Here are 4 more tips on reading cases. 1. Dissents. Students often ask whether they should take notes on dissenting judgments in cases, that is, judgments where the judge disagrees with his colleagues who are deciding the case, and who are in the majority, as to what the outcome of the case should be. I think it depends. If you are reading a recent-ish case, say, one decided after 2000, then I think it's important to read any dissenting judgments, so as to help you see how the case could have been decided, and help you get some sort of critical perspective on the majority's decision. If the case is older than that, then I think it's only important to read the dissent if 1. The textbooks make it clear the dissent is important, or 2. The judge who is dissenting is always worth reading. Reed, Diplock, Denning, Hoffman, Bingham, Brown, Sedley are the only post-1945 judges who come to mind as being good value for money whatever case they are deciding. 2. Remembering cases. Students often find it a challenge to remember cases. Cases are a lot like small, shiny beads. If I told you to hold out your hand, and I poured 50 such beads into it, it's doubtful whether you'd be able to keep hold of more than 10 of them. All the rest would simply bounce out of your hand and fall onto the floor. But if I ran a string through 50 beads and tied the two ends of the string together, you'd have no problem keeping hold of all of the beads in one hand. In fact, all you'd have to do is hold one of the beads, and all the rest would be under your control. Cases are the same. If you try to remember them individually, the likelihood is that you'll only remember 1/5 of them. But string them together, and you won't forget a single case. So how do you string cases together? Well, what you've got to do is come up with a story that helps explain why the cases were decided the way they were. Say you've got 15 cases to remember, and those cases were decided over 40 years. There are a number of different stories that you could tell to try to link these cases together. You could try to find some basic principle which explains the outcome of the cases. If you can, then you've got a story that can link all of your cases, even the ones that don't give effect to the principle in question. You could say, almost all of these cases give effect to the following principle. For example, in case A. Similarly, in case B. This is also true of case C. However, in cases X, Y, and Z, the courts chose not to give effect to this principle. For example, had the courts given effect to this principle in case X, we would have expected them to find in favor of. But they didn't. Similarly, in case Y. A more radical version of the same story would identify a fundamental conflict in the law, with roughly half of your 15 cases giving effect to one principle, and the other half giving effect to a completely different and opposed principle. A battle of the cases storyline can prove very effective at helping you to remember a large number of cases, because battles are always interesting and therefore memorable. But don't invent battles where none exist. The story that you come up with to link your cases must actually work. Otherwise, the story will have no plausibility and will be extremely hard to remember, just as it's hard to remember the details of a crazy dream where all sorts of people were acting in odd ways. Alternatively, you could try to find some political links between the cases, seeing them as reflecting various basic political views, either libertarian. The only thing the state should do is to protect us from being harmed by other people, or utilitarian. The state should take steps to maximize the net welfare or happiness that exists in society as a whole, or right-wing liberalism. The state should generally act to maximize everyone's freedom to live their lives as they want, or left-wing liberalism. The state should generally act to minimize inequalities of income and opportunity in society, or perfectionism. The state should encourage people to live morally worthwhile lives, or communitarianism. The state should protect, elaborate, and give effect to the shared understandings, practices, and traditions that are essential features of our community. A third possible storyline is to link your 15 cases to one master case, which all your 15 cases have descended from. For example, a very effective storyline that would link your 15 cases together might go: in Roe v. Doe, the House of Lords decided that. Applying this decision has created huge problems for the courts ever since. In case A, the courts applied Roe v. Doe to find. But in the very similar case B, the courts came to a very different conclusion, holding that, and so on. So if you want to remember lots of cases, remember them in groups, where each group of cases is linked by a story that helps explain why they were decided the way they were. Remembering cases in this way will not only work wonders for your ability to recall cases in the end-of-year exams, it will also, of course, help deepen your understanding of and interest in the law, which is all to the good. And of course, don't miss out on any opportunity to use cases. Talk about them with your fellow lawyers. Participate in moots where you will be called upon to use cases. Write as many essays and problem answers as you can, even if no one else ever sees them. Take advantage of any chance you get to talk about or write about cases you have studied. The more you use cases, the more deeply they will penetrate into your memory. 3. Casebooks, cases, and materials books. Generally speaking, I'm not a fan of casebooks or books that gather together a lot of cases and materials. They are useful when you don't have ready access to a law library. But I don't think that even as huge as they generally are, they cover as much material as you would want to be familiar with for the exams. And I do think it's more helpful to your long-term memory of the cases not to be presented with them on a plate. The acts involved in 1. Settling down to try to make sense of the facts of the case. 2. Finding out what the case decided. 3. Trying to figure out why the judges decided the case they did. 4. Determining which bits of the case you are going to make a note on, and which can be safely ignored. All these things help get the case into your memory and help you start thinking about it and using it. 4. Ratio decidendi. If you've read any introductory books on studying law, you may have been expecting me to give you some advice in this letter on how you discover the ratio decidendi of a case. Just in case you haven't read any introductory books on studying law, the ratio decidendi, or ratio for short, of a case is the rule of law that underlay the decision in that case. In practical terms, the only time you'll ever have to worry about finding the ratio of a case is after you've left university and you've started practicing law. If you are arguing a case in court, you may well be called upon to discuss what the ratio of a case was. For example, suppose there is a dictum in a previously decided case that is unhelpful to your argument. If you can establish that the dictum was obiter, that is, not essential to the outcome of the case, in other words, not part of the ratio of the case, then you can invite the court deciding your case to disregard that dictum. Alternatively, suppose there is a dictum in a previously decided case that is very helpful to your argument. In that situation, you will want to establish that that dictum was part of the ratio of the case, with the result that the court before which you are arguing your case may be bound to apply it. But as a law student, you'll never have to spend time determining what the ratio of a case was. You obviously need to know what the judge's reasons were for deciding a case in a particular way. But you don't need to know how to take the further step of determining from those reasons what we can say was the reason for the decision. So I'm not going to waste your time and mine discussing such things as how you determine what the ratio of a case was when 3 judges all decided the case in the same way, but they all gave different reasons for their decision. Instead, I'll finish now and write to you in a few days about the different kinds of reports that we find cases in. This is pretty important for you to know. It'll help you to make sense of the systems for citing cases that lawyers use. All best wishes. Look.